These are the wrap-up slides on Class 7. So the Arthur Andersen story has to start at least no later than Enron. And so the way in which Enron rose, the fact that it had seemingly meaningful skills with regard to organizing these online marketplaces because of its experience with the deregulation of natural gas. Enron takes off and grows really rapidly amidst the internet bubble. Jeff Skilling leaves as CEO in August of 2001, and that seems hard to understand. And we head into the press release for the third quarter earnings report in 2001, where Enron is going to announce that it has a roughly $1 billion in non-recurring losses, as it wants to characterize those. And we see this email exchange internally in Andersen about how to manage that. So the Nancy Temple email from October 12, 2001 that we put up on the screen, which the room seemed to think reflected clearly an effort by her to have a paper trail that worked to the benefit of Andersen. And then the Duncan memo, the drafting process of that, where again Andersen was trying to shape its image on paper amidst what seems to be document destruction, at least as laid out in the government's eventual indictment. We talked through a little bit how we thought 1512 should apply in the case of a single firm. We noted in the discussion that the heart of the statute, as at least as applied in the Andersen case, is on this idea of one person corruptly persuading another person. And much of the analysis in the Supreme Court focuses on this idea of what constitutes corrupt persuasion. There's a more basic issue there that it was important to get on the table, I thought, which is this idea of, should we apply 1512 at the level of individuals within the firm, or should we say that a single firm in some sense is a single entity and can't corruptly persuade itself, as I couldn't corruptly persuade myself as an individual? Unless that idea be thought to be, unusual, I put up the idea of what we see in antitrust law, where the antitrust doctrine in Copperweld says that a parent and its wholly owned subsidiary can't be found guilty of a Sherman Act Section 1 violation because they have a joint interest. They don't have the requisite separateness that Section 1 of the Sherman Act requires. And you could imagine that that same idea would apply in the context of 1512, though that doesn't seem to be the case with regard to how it's applied. Part of what we saw in the Andersen discussion was the broad power of the federal government. So the decision to indict Andersen was almost certainly a decision to end that firm as a meaningful economic entity, and the government understood that. And understood that that would be the case even if things change going forward. Change going forward how? Well, we know at the end of the day, when the case goes to the Supreme Court, Andersen actually wins 9-0. So in some sense, a remarkable unanimous victory, but one that comes much, much too late for Andersen as an entity and for many of the individual partners. From there we went to the second example, which is the KPMG situation and then the Stein case. The central allegation from the government's perspective was that KPMG had engaged in a variety of tax shelter fraud. And the core allegation there was that KPMG had looked at the expected costs and benefits of complying with the law and not complying with the law, and had concluded that given the likelihood of getting caught and the potential penalties, that violating the law was a more profitable path for KPMG, and therefore they violated the law. We had a great discussion in class about exactly those issues and the circumstances under which a firm should violate the law, how much certainty the firm should have, whether we should think that what the law effectively does is to tell you the price of doing something, and that if the government's not deterring the behavior they want to deter, then they've mispriced it. Versus the alternative view, which is, under no circumstances should you knowingly violate the law. Also, a discussion of to what extent the firms should try to distribute those values throughout an organization, and to what extent they ought to try to hardwire those. And that was what the dominoes example involved. Obviously, the other issue in the KPMG case that we saw is this strong pressure that the government was applying to KPMG, but the ability to threaten KPMG with a possible indictment as they had done for Andersen. The consequences of that for KPMG as an entity gave the government enormous leverage in its negotiation with KPMG. And those negotiations were framed with the perspective that what was going to happen there is that KPMG was going to take whatever steps were necessary to preserve KPMG as an entity. And that meant establishing that there was a group of people who would be held liable. So the gap between KPMG's interests and the interests of the individual partners, a gap that we see implemented through pressure with regard to litigation reimbursement, but also just direct legal advice, was, I know, having talked to a number of people, eye-opening and quite stark about the gap between the interests of the firm in that situation and the interest of the individual partners or employees.